Now we are beginning the question answer session. So I would request the participants to post their questions in the chat box. We have two questions for Dr. Bhatt. I'm mentioning the first one right now. For the first question is, do you think the extension of schemes like UDAN could be the way forward?
Extension of the schemes like UDAN might not be the way forward, especially because UDAN is basically done for those areas which are not well connected. The smaller airports wherein actually the aircrafts, airlines are actually reluctant to have the slots. So for the purpose of furthering that and having better connectivity in India, UDAN has been brought in. And state might not be able to do this throughout India, especially because this is similar to that of actually the subsidization or maybe the aspect of government support, which I basically pointed out. And it requires a lot of pumping in of the funding by the state. I'm not sure how much of the fund would be available for the state for the purpose of doing this in the entire country level. So UDAN might not be an answer. It might result in actually eating up too much from the state exchequer.
Okay, sir. The second question is no fault liability upon a carrier only in the event of an accident? And corollary to this question is infection caused while traveling, will that also be covered under the definition of accident?
Okay. So first of all, let me tell you that accident need not be the say crashing of the aircraft. There is no requirement of collision or crashing of the aircraft for the purpose of constituting an accident. The general definition, which has been, I mean, of course, there is no definition in the treaty. Generally, it has been understood in the different cases as happening of an unexpected event. Happening of an unexpected event. And Professor Attila has already pointed out about a couple of cases, Sachs versus Air France, wherein actually the court said that you bodily condition, if at all it results in any injury, that is not sufficient for the purpose of claiming compensation. One need to prove accident independent of the injury, whatever has been caused to the passenger. Right? So Sachs versus Air France is an example for that. But then there is another case. There is another case, Dias versus Trans Brazil Airways, which has been followed even in India. Yes, is there any other comment? Yeah, there's another case, Dias versus Trans Brazil Airways, which has been followed in India in many of the other judgments. Dias says that there was a situation wherein the passenger got affected with pneumonia, especially because the condition of the air, the quality of the air inside the aircraft was not good. The passenger got infected and the passenger died out of the pneumonia. The court said that this constitutes as an accident, despite the fact that there might have been actually say some kind of a bodily less resistance towards the bad quality air inside the aircraft. The court said that this is an accident because it is unexpected. The carrier should have cleaned the aircraft in such a way that there is no such kind of such kind of actually inferior quality of the air inside the aircraft. So probably same logic might be extendable to Corona as well. An argument may be put forward, especially it is up to the lawyers. They will definitely put forward an argument by saying that the airline has completely failed to sanitize the aircraft and consequently this kind of infection has happened. So that argument is possible. That's why I said that, of course, proving accident is not that easy. There are difficulties in proof of the accident, but the lawyers are there for the purpose of doing this. So carriers need to be careful in terms of this.
My name is Patrick. Can you see me? I hope. I'm the guy with the glasses and blonde hair, or it used to be blonde. It's rather gray, but I still have got hair, as you see. In any event, Attila, it's good to see you. May I make a comment? Because nobody else has made questions in writing and a question, okay? Hello, everybody. My name is Patrick, and this afternoon I'm going to talk about aircraft financing with my colleague Hamid from Unidroit, but this morning it was all about liability, passenger rights, safety, and so on, which of course is a crucial aspect. But imagine now, let's say someone 74 years old 2 months ago, open heart surgery, uh, and intending to travel as soon as possible when COVID at least has stabilized. When I hear you all talking, I think this person, and maybe that's me, I should be extra careful what I'm going to do. You scare me off entirely. As I said, I'm a finance lawyer, aircraft finance, and this is all making passengers very, very scary. What Attila told me about liability of the airlines, and yeah, Dr. Bath, and you too, about all the regulations. Uh, I guess I better stay home, right, for the next year. And one thing, honestly, I am missing is the fact that modern aircraft, that's what we are talking about, because we all need more, we are all consumers, we are all passengers, we all need modern aircraft, which are safe aircraft, hopefully well maintained. And so far, competition has been discussed also, and investment from governments like in Europe has been, but nobody has said that also yeah, there is in most countries there's a big need for money to acquire privatized airlines, and if they don't do so, you get all the dangers which you have been talking about. If they don't have money and are not state controlled, and then you get the conditions and the situations, a lot of them which you have been talking about. Am I correct in understanding that? That there is a real need for money first, and then you can buy airplanes, and
Yeah,
if
the
there are no
safety is the
airplanes.
first. Safety is the first order. Patrick, you know very well. Money is of major concern, but this industry is one of the safest industry in the world. So, of course, safety is the top priority. As Dr. Kotait said, it mentioned this morning his name, the former president of ICAO. This is never sleeps. It's 24 hours, etc., etc. But answering for your issue just very shortly, the condition of carriage is one of the key issues. The condition of carriage is every airline in the world says it's forbidden to travel who is infected, who has a disease and infect the others. It is forbidden, first of all. So the air carrier liability is now it's a fixed. Condition of carriage is part of the contract. We know very well. It's a unilateral action by the airline, and it's covering the whole issue. Because if you want to travel by air, it is your responsibility, but the airline can deny you because of safety reason. So it means if everybody has a wheelchair, they cannot handle it. There is a limited number of wheelchair, limited number of eye dogs for blind people, number of many things which is in the condition of carriage. And if you read it carefully, each airlines, of course, before your flight, it says what you can do. Of course, airlines wants to have money. Airlines take care of you. Airlines doesn't make difference between handicapped or passengers with special needs and other passengers for sure, because it's business. But you can travel, so you don't stay at home. If you fulfill and the airline accepts, you can combine by the doctor. If you have a medical something stuff, you can prove you are strong enough and you are not infected. Others, you can travel, of course.
But you still recommend a wheelchair, right?
It's limited number only, limited number. Of course, because of the safety, just imagine there's emergency landing, how can the other escape if there are too many people who are traveling with this? But it's each airline's different condition of carriage, of course, and you have to take into account of this issue.
I should recommend, Professor, I think you should ensure that the Montreal Convention applies to you, not the Warsaw Convention or the related instruments. Just in a lighter sense, I said that actually, if the Montreal Convention is applicable to you, that would be better. I mean, if the jurisdiction is falling within the ambit of the Montreal Convention, the passengers would be having the better protection than under the Warsaw Convention regime.
But some countries don't have the money to supervise the safety. They don't have it. So my question is now direct and specific. Why do they not permit these countries I'm specifically talking about? Why do they not? And possibly India is one of them. Why do they not permit registration in a safe haven in another country, based on Article 83 bis Chicago Convention, for example, that they will know that the oversight of the safety will be undertaken by another jurisdiction, while the aircraft are permanently operated in the country of operation, possibly India. This is not permitted under Indian current law. And that may help, like not Belarus, but Kazakhstan, for example, to keep the area Eastern Europe has done so, that the entire fleet of the state-controlled, 100% state-controlled still, local carrier, the whole fleet is registered in another country. And for that very reason, for example, they are permitted now to fly to the European Union. Otherwise, like the other airlines from that country, Kazakhstan, they still cannot fly to the European Union due to safety reasons. So is that not maybe helping if countries like, with all respect, India, would permit this as well? That's the question. And maybe for Dr. Baat, for Professor Baat, our colleague.
Yeah, thank you for that question. But I should say that probably India is in the other end of the pendulum. If you look, actually, the Indian response to the aviation sector has been always very conservative. It has been very, very conservative, unlike actually the Europe or maybe the United States for that matter. And in fact, we even did not allow the foreign investment to a greater extent in the aviation sector. Right? We are just coming out of that. Very recently, we have allowed the foreign investment in the aviation sector, and also none of the foreign airlines were flying in India. They did not have independent existence until very recently. Now only actually they are liberalizing that. So thinking about foreign registration and flying in India is a far-fetched dream. Probably it might not happen in the near future, given the policies which has been adopted in Indian level.
Thank you so much. There's just one question for Ms. Olga, if I can ask it.
So with your all permission, I will take leave. So I have to go for the other session. Thank you so much for all of you. Thank you.
Sir. Thank you so much. Dr. Attila, you wanted to add something?
Yeah, just to Professor Battle, a good news. Montreal Convention is now ratified by 137 contracting states, and the Warsaw Convention only 152. So only 15 states is not party of the Montreal Convention. Montreal Convention is prevailing. So if somebody is a party of the Montreal Convention, it means the Warsaw Convention is not exist. So the future is Montreal Convention, and the Warsaw Convention is also has a great impact to the legislation and to on the via case law. But it's now changing. Thank you.
Sure, sir. The next question is for Ms. Olga. The question is, what challenges do you face in the implementation of Annex 19 with respect to Annex 19 dangerous goods regulation?
Thank you for question. We have some challenges to face the implementation Annex 19. There have some problems with coordination with government agencies, because some government agencies don't understand standard and recommended practice, don't understand requirements of ICAO. It is very difficult problems. And when we do national program of safety management, all documents, aviation rules, regulations of we have some problems with Ministry of Economic, with all lawyers in these agencies. And every day when we do our documents, we we see all standard and recommended practice. What we do about requirements of ICAO. This is the main problem of implementation Annex 19 to the national legislation. And the question about dangerous good regulations, we have aviation rules of the Republic of Belarus adopted by Ministry of Transport of Communication of the Republic of Belarus, and this regulated this document regulated dangerous goods, and in our national aviation rules for the cargo of dangerous goods apply. This agency is ministry agency, excuse me, Ministry of Agency Situation is activities involved. Because we have two regulations, the Ministry of Transport and Communication of the Republic of Belarus, and Ministry of Agency Situation is activities involved. Thank you. Do you have?
Thank you, ma'am. There are no more questions, so I think I'll conclude the session now. I would like to thank our panelists, specifically Dr. Attila Sipos and Ms. Olga Kulusic for joining us today and informing us about your respective topics. It was truly an insightful session. Thank you so much from the CMR team.